What happens to your kids if you die without an estate plan? Hi, I'm OC estate plan lawyer Michael Pevney. You can visit me at ocestatePlanLawyer.com and click the link to book a free 30-minute estate planning session. So today we're talking about what happens to your minor children if you die without an estate plan. And the simple answer is a judge decides. Maybe your parents or a sibling might come forward, and if they're the most appropriate person that a judge says should take care of the kids, they're going to be appointed the guardian. They basically stand in the place of you, the parents, if you're gone. The way to prevent this is to have in place a complete estate plan where you get to choose who the guardian is going to be. This can be done through a will or through a nomination of a guardian paperwork that should be part of any estate plan, especially if you have kids. And you get to choose who that guardian is going to be, because the reality is you might not have a great relationship, or for whatever reason you might not think that the person the judge appoints as guardian without an estate plan is the right person to do the job. So there's a few factors that should go into choosing who that guardian is going to be. One is, where do you want your kids to live? Do you want them to stay in the same town that they lived in before, or are you comfortable with them moving out of the area, out of the county, out of the state? Do they have the same general outlook as you or your partner? Do they have the same religious tradition? Do you want them raised within a certain religion, if any? Do they know about the goals that you have as a family? Are they capable of providing the kind of emotional support that you want for your kids? Are they in a stable family situation? Are they in a stable financial situation? Are they someone that you're comfortable having around your kids? And maybe the most important thing is, have you spoken to them about it? You don't want somebody to be appointed a guardian who has it sort of thrust upon them without any prior knowledge. The guardian is the person that has physical custody of the kids, of any kids that are under 18. And if you have a revocable living trust, you appoint a trustee, or rather a successor trustee, because you are going to be the first trustee having control over the money. If you don't have a revocable living trust, or a trust overseeing where the money and your assets go, your kids are going to get that property, if you want them to have it, when they turn 18. So you might have hundreds of thousands of dollars or even over $1 million in assets. And those kids are going to get those assets when they turn 18. You have to ask yourself, is that a good idea? I don't think it is in the huge majority of cases. I know I would not have done well had I had hundreds of thousands or $1 million when I turned 18. With a revocable living trust, you have a lot of control on how your estate is distributed in your passing. You can appoint a successor trustee to oversee that, and you could give them as much or as little discretion as you want over distributing that estate. That money can go to the kids only after they've achieved certain milestones, whether that's getting a college degree or at certain points in time. They get a third of it when they turn 25, a third when they turn 30, a third when they turn 35. A trust can also prevent the distribution of your estate to the kids if they have an abusive or overbearing spouse. If they're being sued and someone's trying to get a hold of their money, the trust can maintain ownership and control of that money to prevent that money going to someone else who isn't a child of yours, or if it's not in their best interest at the time. So oftentimes when choosing a successor trustee who's going to control the money, you might not want to have the same person be the trustee that's the guardian. Maybe you have a sibling that loves your kids and is great with your kids, but might not be the best person with money. And maybe you have a close friend or an aunt that is very prudent and very organized and very good with money, but maybe they live far away, or maybe they don't have the same kind of relationship with your kids as your sibling does. So it's important to think about who is best with money and who is best with the kids when choosing who is going to be the guardian and who's going to be the successor trustee of your revocable living trust. It's also important to think about the relationship between those two people. Do they get along? Does the guardian get along with the trustee? Are they going to be able to communicate well with each other? It's also always a good idea to think about what's going to happen in the future as you get older and as your kids get older. What's going to happen to the guardian? If you choose your parents, the kids' grandparents, They're aging, they might be have some health issues of their own, and they might not be in the best position to take care of those kids 5 or 10 years down the road, which is the reason that it's always a good idea to have some backups in mind. At least one backup, ideally 2 or more backups, to be both the guardian and the successor trustee. With a complete estate plan, all of your documents, a pour-over will, a nomination of a guardian, and a trust will all work together, making sure that your kids are properly taken care of and that your estate is distributed in the way that you want it to be and by the people that you want it to be distributed by. Thank you very much for watching. This is OC Estate Plan Lawyer Michael Pevney, ocestateplanlawyer.com. You can click on the link to set up a 30-minute estate planning session. Once again, thank you for watching.